Hello, everyone. It's a pleasure to see you here today, and thank you for joining us. Before we start our meeting, I want to inform you about some technical details. The discussion will continue approximately 2 hours. It will not be translated online, and it will be just recorded, and then we will place it on our web page of Democracy Index Georgia and independent lawyers. So now we can start the meeting. I have a pleasure to open the discussion on this very important and significant issue, which is public access to court decisions. With support of USAID Georgia Rule of Law Program, we have today this great opportunity to exchange thoughts and share experience among so amazing participants from different countries and different jurisdictions. Before I ask our representative of USAID Rule of Law Program, Anna Jobava, to address our audience with opening remarks, I will just share with you some news about International Network of Judicial Reformers. During 1 year, we are not only organizing the discussions on different topics and problematic issues, but also we are working to reach out even more countries and representatives of different jurisdictions. So our network is growing and we have quite interesting discussions and other events ahead. This event today is organized by Democracy Index Georgia and group of independent lawyers. For more future events and activities about our network, you can follow us on our Facebook page and also web page of Democracy Index Georgia and independent lawyers, where we also have regularly updated news about judicial reforms of different countries. So why was the topic of court decisions selected for today on discussion? In Georgia, access to court decision has been a problem for years. Georgian courts do not publish proactive judicial decisions, which significantly restricts public scrutiny over the court system. And now we have a decision of Constitutional Court, and as it ruled in favor of publicity, Georgian Parliament has a problem and faced the issue to keep a balance between the right of publicity and right of privacy. Countries approach this task differently. And today we will discuss 3 different models of publicity of court decisions, which is a very important question. I also want to inform you that the discussion will be moderated by our colleague, practicing lawyer with significant experience and a member of group of independent lawyers, our moderator, Irakli Korzakhia. Now I want to ask our representative of USAID Rule of Law Program, Anna Jobava, to address our audience and to say some opening remarks for today. Anna, please.
Thank you, Kata. Greetings, everyone. Our program has been supporting the group of independent lawyers and Democracy Index Georgia for the last few years. And we are very glad to see that one of the policy research projects which we supported a year and a half ago resulted in the creation of this network of judicial reformers. Practitioners from Central and Eastern Europe, as well as other countries, exchange information on highly complex issues of justice sector reforms. Today's discussion is extremely timely and topical for Georgia, and Keta already mentioned a couple of reasons why this is the case. Access to court decision has been problematic in Georgia And despite the Constitutional Court decision, which was adopted in 2019, the issue remains problematic. And also, I have to say that this issue, I think it's Aha's microphone, right? That keeps interfering. This issue also has been placed at the top of the agenda for the agenda of judicial reforms, which is considered not only as an internal issue, but also as a part of the Georgia's EU integration process. And it was discussed internally between the ruling party and the opposition, and including in the agreement, which was negotiated by EU. And most recently, it has been considered as a part of the conditionality for Georgia's accession to the European Union, Georgia receiving an EU membership candidate status. So, and Kata also mentioned that the Parliament of Georgia has drafted legal changes regulating this particular issue, and these changes are currently considered. So that is why I really looking forward to today's discussion, and we think that the insights and experiences that will be shared will be very, very valuable and informative for Georgia. Thank you.
Sorry. Thank you, Anna, very much. Now we can move to our discussion, and I wish you all two fruitful hours. And also I want to kindly ask you to be very close to our agenda to try your best. Thank you very much. And I will ask Irakli to make other aspects of just to moderate our discussion.
Do you hear me? Yes, yes. Welcome everyone. I was chosen to be moderator because I have image that I'm very strict on timekeeping, which is not true, but I have to meet expectations, so I believe will be quite strict on timekeeping. I will inform, all presenters, excellent presenters, when there's 3 minutes left and 1 minute left, and that's how I'm going to keep time. So our panel discussion shall be opened by Kaha Tsikharishvili, member of the group of independent lawyers. And he will present, his topic is 3 models of access to the court documents and the case of Georgia. Kaha is legal researcher. He was member of disciplinary collegium. He was also assistant to Chief Justice of Georgia. He has extensive experience in civil society work. He was chairman of Article 42 of Constitution, and now he's the member of group of independent. He's extensive lecturing experience in criminal law and other topics, but at this moment, as a member of group of independent lawyer, he was very active in researching best practices in the topic of judiciary, and also he has worked on the various reform initiatives to strengthen judiciary in Georgia. Kaha, floor is yours, so you have 10 minutes to present your topic, and we are listening to you.
Thank you very much. I hope you can hear my voice. So,
yes.
Everything okay? So thank you very much. The topic of my presentation is three models of access to the court documents and also the experience of Georgia. First of all, why court documents? Why not decisions, specific decisions? Because when we talk about the court documents, we also imply the files, the case files. Actually, today's discussion also we're going to touch, mostly we're going to concentrate on the court decisions, but we can also talk to the access of the case files. How are they accessible, and if they are accessible for the parties? I'm going to start with a specific case that we had, me and Irakli. We went to the court and we wanted to obtain a decision on a specific case, which is a very famous case. Former president of Georgia, Saakashvili, he was convicted in absentia on a Giuliani case. It's covering some murder, covering some criminals by his act of clemency, and that's a very controversial public case. And we wanted to obtain a decision on this case, a court judgment, the trial court judgment on the case. And we were refused by the court. The court did not give us the judgment because of the right to privacy. Then we appealed this decision in the same court to just by way of administrative appeal. And the court gave us the reasoned decision which says that because of the right of privacy, we cannot have that decision. Now, there is a very big debate on this specific case in Georgia and also on Saakashvili criminal trials. And we wanted to actually make a discussion, a roundtable, an academic discussion on this issue, but the decision was not given to us. Actually, we have obtained that decision from other sources, but this itself, by itself, is a very clear example of the problem that we have here in Georgia. Now I'm going to talk about the decision of the Constitutional Court that was here in Georgia in June 7, 2019. The Constitutional Court of Georgia assessed the constitutionality of the legislation, which prohibited the public access to the court decisions. And the Constitutional Court has assessed two values: access to public information versus right to privacy. And the Constitutional Court has analyzed the importance of the right of access to the public information and also the importance of the right to privacy. The Constitutional Court said that right now, today, the balance is not kept in favor of access to the right to public information. The balance is kept in favor of the right to privacy. So right now in Georgia, everything is closed. The courts do not give any court decision because of the rights of privacy. So, there was also a discussion about the category of private information. I mean, what kind of private information do we have? There are different degrees of privacy and different degrees of private information. And there is a special category of private information, which is the court records, which is a criminal conviction, status of the victim, sexual life of a person, health of a person. This is a special category of private information. And according to the current legislation, the special category, the private information of special category, can never be disclosed publicly without consent of the person. So the Constitutional Court said that this is not the right balance. It's not constitutional. So the Constitutional Court declared those provisions unconstitutional, and now we have draft law pending in the parliament. a draft law pending in the parliament. Now, before I go to the draft law, so I have to talk about these three models of access to the court decisions, which is based on the based on IDFI study. Here in Georgia, we have a good study in Georgian language, also in Georgian language, which is in 2017, which was made by NGO IDFI, and there you can see very well what kind of models exist for access to the court documents. So there are three types of models: full accessibility, so court decisions and case files are accessible to the public in full, subject to the limited exceptions. Decisions are published online and can be searched via different engines. The second model is the limited accessibility. Court decisions are accessible in anonymized form. In some countries, only high instance court decisions are accessible. And three is the medium accessibility. Judge or court may decide case by case to provide access to the court decisions. Some courts may adopt guidelines, and judges may have wide discretions in granting the access. From these three types of models, we now have the model of limited accessibility. In Georgia, the court decisions are not accessible to the public because of the right of privacy. Now, let's talk about the law which currently exists here in Georgia about publication of court decisions. This is Article 13 of the law on common courts, which says that every decision which is adopted as a result of the open court session shall be fully published on the website of the court. However, the personal data, the issue of the personal data shall be resolved in accordance with the law. So that's what the law says. The law says that every decision should be published on the website of the court. However, the personal data, the issue of the personal data should be decided according to the law. So what kind of situation do we have right now? Irakli, do you have a question? Sorry.
3 minutes.
Of course. So we have a situation where the Supreme Court decisions are published here. Right, you can see those decisions. I'm just showing you the website of the Supreme Court. It's a website of the Supreme Court. You can find the Supreme Court decisions, and trial and appellate court decisions are published until 2020, but not after 2020. So the courts are right now violating the law because they are not publishing those decisions. And decisions are published in an anonymous form, so they are anonymized. Right now, they are anonymized right now. So what about the draft law? What does the draft law say? I'm going to talk about the draft law and the draft proposed by the Georgian Dream and draft proposed by the opposition. The draft law, which was proposed by the Georgian Dream, says that when the court is making a decision on a specific case, the court has to decide case by case, the publicity and public accessibility of that decision. So the court has to notify everyone who is mentioned in the decision, every witness, every party, every defendant about this possibility of public access to the court decision and obtain their consent. Obtain the consent. And why I'm saying this is a very peculiar law which places unreasonable burden on the judiciary to obtain consent from everyone mentioned in the decision. So you have to send a notification to the witnesses, to the parties. You have to ask to the people who come in the court, are you willing to publish your data? And I think this places unreasonable burden on the court. We can talk about that later. And the alternative option, this is coming from the opposition. The alternative draft is coming from the opposition. According to this draft, the decisions are public, subject to the exceptions. All decisions are publicly accessible, subject to the exceptions. So the persons who are mentioned in the decision, they can ask for their anonymity. They can ask their anonymity, and this is going to be decided on the balance of on the scale of according to the scale of balance of interests. every case by case, this is going to be decided by the court, but the presumption is for publicity. So if you want your case to be anonymized, or if you want your data to be anonymous, you have to go to the court and you have to ask for your data to be anonymized or not to be disclosed. This is the major principle. So basically, right now we have these two legislative drafts. First draft, the court is asking everyone, and in the second draft, the court is not asking to no one, just you have to go to the court and you have to ask for your data to be anonymized. That's it. I think I've finished my presentation. Thank you.
Thank you very much, Kaha, for keeping up with time. It was really interesting presentation, and it shows that Georgia is on crossroads, choosing full accountability, limited publicity, or this mixed system. So we'll see. It's an interesting development is going on in Georgia right now. So our next presenter is Jim Moliterno, Vincent Bradford Professor of Law at Washington and Lee University School of Law. I know many of at least my Georgian colleagues know Jim Moliterno very well. In addition to his teaching career in the United States, he has he was engaged in substantial international legal ethics and legal education reform work, designing new lawyer and judge ethics courses in Serbia, Armenia, Georgia, Czech Republic, Japan, Indonesia, and Thailand. He also trained law professors in China, Thailand, Georgia, Armenia, and Serbia. He also worked to revise legal ethics code in Thailand and in Georgia, and lectured extensively international lawyer ethics topics in Spain, Czech Republic, and Slovakia. He has prepared course materials that are in use in Serbia, Armenia, Thailand, Czech Republic, Japan, Australia, Indonesia, and China. I think Georgia is missed here because his course material are used in Georgia in continuous legal education in Georgian Bar Association. Also, his excellent books in global issues in legal ethics was translated in Georgia and was used by lecturers when teaching legal ethics courses in Georgian law faculties. He's one of his last article name is Independence Without Accountability: The harmful consequences of the EU policy towards Central and Eastern European entrants. So when we are speaking about public access to court decisions, we know that it is part of judicial accountability. So Jim, floor is yours.
Roughly, I think Jim is missing now. Maybe he has a problem of...
We don't have Jim?
We don't have
among
him
participants?
Not yet.
Not yet. So if you would not mind, we can meanwhile discuss some technical issues with Jim, and we can ask our next presenter, Judge Helen Best, yes, Judge of Bremen District Court, to have her presentation. Switch places until Jim will join us. I'll briefly present Judge Best. She's vice president of the Bremen District Court since 2012. Where she has been working as a public prosecutor since 1993 and judge at the regional court and district courts in Bremen. She has international experience from 2004 to 2005. She worked as a senior legal expert in Georgia for the European Council, in team with colleagues from various European countries to support the law enforcement authorities and criminal justice system in Georgia. She has also been expert in Kazakhstan, Kyrgyzstan, and Uzbekistan. She was also spokesperson from the Permanent District Court before she was appointed as vice president. It will be interesting perspective from German experience, because in Germany, as I know, you have very strict personal data protection, and sometimes it prevails over access to full court decisions. So, floor is yours. I'll keep up time.
Thank you very much. Hi, everyone. In Germany, of course, according to the law, which is based on international law, Article 6 Human Rights Convention, everyone has the right for a fair trial, and this includes the right to inspect files. But as I understood, you are not so much interested about these rights of a defendant or a plaintiff, but the public. So I will change a bit. So judgments of our federal courts and constitutional court and so on, they are all published. This is not a problem, anonymized, always. And in other courts, like we have 16 states, and we have in our states we have also high courts. They publish their most important, or what they think are their most important decisions, but it is always anonymized, and it is always after legal effect, or res judicata. Only their acceptances. Me personally, not long ago, I had a case which was very popular, and when it was challenged, and the next court decided different to my judgment, and many people were very interested in my reasonment. And because this case was so popular, we decided to publish it, but without the name of the defendant. There were no witnesses, and it was just a question how to apply law. Everyone who is interested knows who was this person, but nevertheless, we anonymized. So, like in your case, Kaja, a court in the Saakashvili case, in Germany, a court would, not the chamber, but the president of the court would decide if you can have this decision. And in Germany, you can be sure it would be decided anonymized. You could have a decision after legal effect. Before, it's difficult. Has to be decided from case to case. But when it's after legal effect, then but this is only for these cases which are very popular. It's different, for example, when it comes to other cases like family law. You would never ever publish it. Unfortunately, we couldn't hear now this American colleague, but I know from other meetings, and I read a lot of these Grisham novels, that after legal effect, you could more or less have access to every file in the United States. This is unthinkable in Germany. You know, when you have to dig for something which in a family case or so, this is unthinkable. In Germany, no one would like this. No one would ask for this, and no one wants it. So we have strong restrictions to protect the people who are plaintiffs or who have a divorce or whatever. I give you another example, even for a judge. I'm a judge for criminal cases. If I have my doubts about the mental health of someone and I see this person is under guardianship, even in my own court, I have not access to the file about his guardianship. I have to write something to this court. I have to say there is a legitimate interest. I have to check whether he is responsible for his deeds or not, or do I need an expert about his mental health. So then the judge, my colleague, so to say, only next to my room, would decide if he will give me this file. But always a judge has to decide this. And in these cases, like civil law and criminal law, which where there are public hearings, the same is for administrative laws. Every time there's a public hearing, after legal effect, the president of the court can decide whether this is published or not. Of course, a judge could decide and say, I want to publish my judgment. Some colleagues are doing this because I think it's important. And then we have, you can do it meanwhile online or wherever. But it is always anonymized. You would never, ever write down the name. Sometimes, if it's a very, very popular case where everyone knows who these people were, it might be different. But the normal case is anonymized. If you do not get access, you could challenge the decision of the judge, of the president of the court. But during, as long as the case is running, so to say, it is only the judge, the deciding judge, who makes his decision, and you could not challenge it as long. But after that, you could. So this is, for short, you could even ask something now.
Yes, I'm sure. Thank you very much for providing information. We have the time for discussion and question and answers session at the end of presentation, but we have time till still. So if there will be some quick questions to Ms. Helen Best, we can ask some quick questions.
Yes. Can I will ask a couple of quick questions directly, if possible.
Yeah.
Thank you very much, Ellen. Thank you for your presentation. It's really interesting for us how it's working in Germany, because we are always talking about the German justice system is how it works like a clock. So we think that the German justice system works like a clock, and so everything is like, everything is in good shape. But the thing about the publication of some decisions and not publication of some, so no publication of some decisions, it's a little bit confusing. So what you say is that everything is not published, and the court is deciding case by case what to publish and what not to publish. And yes, this is the first one. So
Supreme Court, our high courts, federal courts, they are publishing every decision.
Mm-hmm.
Yeah.
Yes.
Because it's very important for normal judges to know. You have to find it, of course, because you are working with this. But then when it goes down and down, the less you are publishing, because no one is interested normally in my decisions, frankly. Who would read this? And this is very short. We do not write much. What could you read? Someone was drunken when he drove the car. Who wants to read this? But you want to read, of course, if there's something special and then the person challenges it, and maybe you change the jurisdiction to a point, then of course it should be published. Otherwise, you do not know what is the appeal court or the cassation thinking about this, of course. And then you have cases like you were talking about, the Saakashvili case. Everyone wants to know, and he's a person of public interest. If it comes to that someone is a person of public interest, you will publish it. And if someone is asking, you would anonymize it, but everyone knows it. Nevertheless, you would, but only after legal effect. You would never ever give something out of the file, even if Saakashvili or whoever, during the trial. Never, never.
Legal effect, you mean first instance appeal, and also when it is just entry, I mean legal force, when it enters, there is no more appeal. You mean there is no more appeal possible?
Yeah, then you in the federal court say they do it. This is like also like a machinery, an industry, and we have these judicial papers and magazines. Of course, you can read it. And of course, every year they publish for a whole year all the decisions, yeah. But not a normal court, only if it's something of interest or something because a person of public interest or a change in the jurisdiction.
Mm-hmm. And one more quick question, and I'll finish. Let's say one example. I have a neighbor, and my neighbor has a dispute with his wife, and mm-hmm. I want to take the decision of my neighbor from the court because I'm a curious person, because you know, I would like to know what's happening in my neighborhood. Yeah. So I go to your court, I come to your court, and I ask you with a specific name and last name, please give me that decision between my neighbor and his wife. Is that possible that you give me that decision?
Yeah, there are two things. One thing is if it was according to the family law, you do, meaning the decision would be you are not allowed to go closer than 300 meters and so on. This is family law. You would never ever get it. There's no possibility because the hearing was, there was no public hearing. Which what was not in public, it doesn't exist for other people.
Okay.
When it comes to the criminal court, then you have a public hearing. So you would write to the president, or he's now he's not here now, so I would be on my desk. I want to have this, and I was why? What is your interest? Your legitimate interest? He said, I'm just curious. My neighbor. I said, no. You will not get it. But for example, if there's an insurance company and saying, maybe we have to pay some money for it because, for example, also, then there would be the possibility to say, okay, we anonymize, and then I will give the decision.
Thank you very much, Ms. Helen Best. We ran out of time, so I could not make any more questions at this moment, but we'll have time for discussion, and I hope you will stay. You have time to stay with us. So I see Jim join us. I already made presentation of Jim's activities and his career and his work. So Jim, you can just jump. Your presentation.
Okay, thanks, Irakli. So I apologize for having the hour incorrect. I think we must have had the fall time change by 1 hour, and it caused me to make the mistake. I thought that we were starting at 9 a.m. my time, but it turns out it was 8 a.m. my time. So I apologize for my mistake on the time zones. So Kaka asked me to speak a little bit briefly about access to court documents and court opinions in the US. And, first of all, I'm sure it's clear to this group that free access, easy access to court documents, with some exceptions, of course, that we'll talk about, but free access to court documents for anyone is critical. It shows that the justice system operates out in the air where everyone can watch what's going on. Anytime we have a system in which court documents are not accessible, are kept private for the most part, we are telling the public, right? We are essentially telling the public that justice is secret. And when justice is conducted behind curtains and closed doors, people don't trust it. And obviously, if we have systems in which people do not trust the outcomes of court decisions and court activities, then it's harmful to the entire society to have that kind of situation. I've actually made arguments to several judiciaries in different countries around the world that this not only includes making the court decisions accessible, like electronically or physically if you're in the courthouse, but it also means writing clear, transparent, thorough decisions by judges, because the more that happens, the more the public is able to see what is happening in justice. Even if it is only the media that goes to read those opinions, if they can understand them very clearly and they are very thorough, they will be able to essentially translate to the public in their media reports. Okay, so in general, in the US, I'm going to try to demonstrate a couple things. I hope the technology will all work today. But in the US, it's very easy to get access to court opinions. Every state, to my knowledge, every US state has a system that allows anyone without any special permission to go in electronically on a website and search court records for particular cases, for particular individuals. And I'm going to do that again if the technology works well. In Virginia, I'll do that for my own state, but you can do that in any state. And there is a system in the federal courts called PACER, P-A-C-E-R. Any of you can sign up for it. It's public access to court decisions electronically. So I'm going to share my screen and see if I can pull that off while we're talking. So I hope you can see my screen now. And here I am, I'm in the federal court system, right? So what if I want to look up cases with a very interesting name? I'm trying to stay in. Okay. You've never heard of this name, I'm sure. Let's say I want to see cases that involve the name Trump. Let's see how that goes. It's too many. It's 5,400 cases. So maybe that's not really what I want to do. I want to do this in a more precise way, because in particular, I'm looking for a case that was important in the 2020 election, when Trump's campaign was contesting the election in Pennsylvania. And so I know that the opponent of Donald Trump in that case was the Secretary of State in Pennsylvania, and her name is Kathy Boockvar. So I've put in her name now. Let's try to search for her name and see if it's better. Where did I go? Let's see. That's how to spell her name. Okay, here we go. So there are some cases that involve her, you would expect, as the Secretary of State of a important state. And I scroll down. Here's the one I'm looking for. Donald J. Trump for President versus Bookvar. It's in the Middle District of Pennsylvania. I click on, look what they did to me. Okay, that one I didn't find. So let's see. Try the other one. Sorry for the short delay here. Okay, here's a different one. Okay. It's giving me a hard time at the moment. But you can see that all of these cases are available whenever the technology works by a simple click. So here are two of the cases.
Jim, could you share your screen?
Yeah, yes, I was sharing it. What happened? Sorry.
It's okay. I paused my timer, so.
Okay, so I'm going to share this again. And it's not making me happy at the moment because for some reason I'm not getting to the actual case. Now you can see it again. But you notice here, here's one of the cases, here's the next case. Either one of those would get me to some of the litigation after the 2020 election in Pennsylvania. I was looking at it about, I don't know, an hour ago, and it was there. And this is actually a court opinion that I showed to my students during my procedure course, my civil procedure course that just ended this fall. So, okay, so that's the federal one. Let's now take a look at, I need to move this. Okay, now we'll take a look at the Virginia page. Okay, and again, you should be able to see my screen, and now we are on the page for Virginia, State of Virginia Judiciary. It says online case information. So I'm just curious, I will look to see I want to see the criminal record of this individual. I happen to know this individual, but he's not a friend of mine. I'll say it that way. Let's see what we get. There we are. So we have the criminal record. You can see my screen, I think, for a young man. He's actually in his 40s, named Richard Flowers. And here we are. So he was charged with a small theft, petty larceny. He was charged with trespass. He's not a very nice guy. He was charged with peeping into a dwelling. Not a good guy, etc., etc., etc. I can take, for example, any of these that I like, and I click on it, and I get more information about that case. So where did it happen? What code section of the criminal code did he was charged with? What was the date of the offense? When was he arrested? Who was the police officer who arrested him? And so on. And finally, we get every time there was a hearing, we can see this happened, then this happened, then this happened. And here at the bottom is the sentence that he received. Okay. So you see how very, very easy that is to look up. Okay, now.
1 minute left.
Sorry?
1 minute left.
Okay.
Two more, maybe one.
No,
one
that's
more
okay.
minute.
I'll share one more very quickly. Now I want to see if a particular lawyer in Virginia has ever been disciplined, been punished somehow. And let's see if I am on the right page. No, let's look at the Ohio lawyer registration. And I'll try to share that one quickly. Here's an Ohio lawyer. Let's see if anybody recognizes this fellow's name. See if he's ever been in any trouble. Okay, okay, so now it's searching, and we can see he is registered, and we can see, for example, down here, any discipline history, no. Any sanctions or suspensions, no. So this must be a pretty good guy that we can find, okay? Now, I can do this with virtually any lawyer in any state in the US, but that's enough. I think I should stop there and ask if anybody has any questions that you might want to ask.
Jim, we'll have this question and answers or discussion session at the end after we have the two more presentations. If you are
very
able
good.
to stay with us, 20
very
minutes. Yeah, I'm sure there will be some questions regarding personal data protection rules, laws, United States or states. So thank you. Okay.
I'll be here. Thank you.
Yes. So our next presenter is Natalia Chumak. I hope I'm pronouncing Natalia's family name correctly. She's deputy head of the State Judicial Administration Office in the Kiev, overseeing the administration of Kiev courts. She was in public service for 30 years and in court administration for 13 years. She before last promotion to the State Judicial Administration, she was a court administrator of Kiev region appellate court, dealing with case flow management, budgeting, operation, and organization support, etc. She is a trainer for the National School of Judges in Ukraine, where she contributed for the development and implementation of various training programs for court administrators. She was also part of a faculty team for Michigan State University Judicial Administrative Certificate Program in Ukraine. So she is also founder and editor-in-chief of Journal of Judicial Administrators in Ukraine, newsletters of the Court Management Institute. So Ms. Chumak has extensive experience in administering courts, so it will be interesting how this dilemma between court judicial accountability and access to court decisions and also right to privacy is solved in Ukraine. So, yeah.
Okay, Natalia is not here. Natalia is in Kiev. She's in Kiev, and you know there is a power outage very frequently in Kiev. She sent a presentation with audio, and I can try if this works because there is a PowerPoint with the audio presentation. So let's see if it works.
Let's try. How would you share your screen?
Yes, I will just do it now, please.
I hope technology will work at the time.
Okay. These are the slides, and it also has the audio. And I'm going to turn on the audio, but I'm not sure it works in Zoom. So let's see if you can hear the audio. Here's the slide. Just a second. Okay, let's see. Sorry, I think I should do it again, once again, in a different way. Just a second. Share with the share sound. Let's see it now.
Decisions in one of the important guarantees of the accessibility of the court procedure.
I'm sorry, can you hear it now? Irakli?
Yes, you can turn audio volume up if you can.
Yes, I'll try to turn it up more to the maximum. Okay. Oh, I think this is the maximum. Let's see.
Transparency of the judiciary regulars ensuring the availability of court decisions for all interested parties. That is why from June 1st, 2006, the Unified State Register of Court Decisions was created for access to court decisions in Ukraine.
Mm-hmm.
The Unified State Register of Court Decision is the automated system for collecting, storing, protecting, accounting, searching, providing electronic copies of court decisions.
Mm-hmm.
All written decisions of courts of general jurisdiction in civil, administrative, economic, criminal cases must be entered into the register.
Sorry, just a second. That's it.
Court decisions entered in the register are open for free round-the-clock access. Users are provided with opportunities to search, view, copy, and print court decisions on their parts. The court enters into the register all court decisions and separate opinions of judges, expressed in writing no later than next day after their adoption or production of the full text. Exception. Information that, according to a court decision, is subject to protection from disclosure, is removed from the text of the court decision. The court decision on granting permission to conduct intelligence activities is not made public. Court decisions on those cases that may fall under the definition of...
Sorry. Okay.
Exception. Information that, according to a court decision, is subject to protection from disclosure, is removed from the text of the court decision. The court decision on granting permission to conduct intelligence activities is not made public. Court decisions on those cases that may fall under the definition of the state secret.
Okay. The next slide.
On the official website of the registry, there is a search form in which you need to fill in the proposed fields in order to familiarize yourselves with the decisions made in the case. Case number, region, court, name of the judge, surname of the participants in the court, etc. In the text of all court decisions which are open to public access, the following information is not indicated: address of place of residence of the person, phone numbers, email addresses, identification numbers, vehicle registration numbers, numbers of bank accounts and payment cards, other information that make it possible to identify a natural person. These data are replaced by letters or numbers. The search in the registry can be divided into two main directions: a search for information on specific case, and analysis of existing judicial practice, including a selection of decisions of a sentence court, a specific judge, etc. Today, the function of the register is a norm of life. We can safely say that with its creation, our justice system has become closer to international standards. Thanks to the work of the register, all lawyers have easy access to court practice, and judges ensure the same application of legal norms their work. The predictability of the results of cases is increased. The possibility for the public to control the activities of the court through court decisions is simplified. In addition to the official register of court decisions in Ukraine, there are also a large number of non-governmental commercial search systems for working with legislation, regulatory documents, and court decisions. For example, the popular Ukrainian portal Legal Law is an informational legal system which a huge volume of regulatory documents and legislative innovations, which has a search system for court decisions, verdictum. Unlike the register, verdictum is a single information and analytical complex and not just a database of court decisions. It was created to quickly and conveniently analyze not only separate court decisions, but also all decisions in specific case. Verdictum provides an opportunity to work with the schedule of court sessions. Second example, ActiveLex is an online lawyers tool that includes program and databases of regulatory, legal, judicial, and reference information. Lawyers like to use this program in court or in meetings when the only device nearby is a smartphone. The precedent system contains document, decision on the European Court of Human Rights, documents of the Supreme Court, decisions of the Supreme Council of Justice, decisions of appellate courts, digits, etc. The site has a simpler two-window interface, filters by jurisdiction, a special mechanism for displaying and sorting found documents. Open Data Board provides access to government data to citizens and businesses. Analysis of open governmental data provides a lot of representative information. It may be very interesting.
I think this is the last slide.
So, today we have various options to access to court decisions in Ukraine. The Unified State Register of Court Decisions is the most complete and up-to-date database of court decisions, but the register is not the most convenient search engine. That is why such systems as Verdictum, Precedent, and many others are popular among lawyers.
Okay. Irakli?
Yes,
okay.
Thank you. So it's all there. Yeah, it was wise to record this presentation due to this power outages in Ukraine. We had to have this in such form. This was rather unfortunate because of the terroristic activities of Russian Federation. I'm just citing European Parliament here. Many Ukrainians are left without electricity and water. So my personal solidarity with brave Ukrainian people. So we couldn't ask questions to Ms. Chumak, I guess. So
actually, Irakli, sorry. I asked one question and I'm going to read out the answer. Maybe this is going to be...
Okay, we can have this, if you have additional information from Ukraine, we can discuss it during
discussion,
okay? So just not to run out of time, I'm going to present next presenter, Ilie Kirtuaga. Sorry, I used Google to correctly pronounce surname. I hope it's not far from the correct pronouncing. So Ilie is the legal researcher and consultant with almost 10 years professional experience in the non-profit sector. His primary legal expertise includes the judicial reform, digital rights, and non-profit law. He was involved in monitoring and evaluating the mechanism and practices of selection and promotion of judges and prosecutors, development and implementation of the percentage designation mechanism, as well as the concept of new legislation in the society field of Republic of Moldova. Since 2022, Ilie has been a member of Integrity Council, a collegial board of the National Integrity Authority. So, floor is yours, Ilie. Let's see how this access to court decisions are regulated in Moldova.
Thank you, Irak, and a good afternoon, or good evening, or good morning to everyone. I have a brief presentation about access to court decision and a little bit about the access to court files. Before I start, do you see my presentation? Is everything all right?
Yes.
We see.
Yes.
Great. So basically, in Moldova, since 2012, almost all judgments, court decisions are published on the internet. We even have a provision from the Supreme Court of Justice that if it is available on the internet, it means it entered into force. So basically, our law conditions the fact that a decision of the Supreme Court is considered pronounced only after it is published on the website, meaning it's publicly available. As in Ukraine, we also have a unified court judgments portal, and you can search by party names, by the case type, civil or criminal or misdemeanor. And we have a separate portal for the Supreme Court of Judges portal. And you can also search by party names, case type, and article incriminated. Or if it is a civil dispute, I don't know, debt or something between the neighbors, you also can search by the case type. We also have a Supreme Court of Justice archive digitized, so all the judgments from 1965 to 2013 are digitized, and it's really interesting from a historical perspective to see how the judgments were in the Soviet Union, but basically they were very short because you didn't have copy paste, you had to type everything. So it's all the essence in 4 pages. And public access to this decision is free of charge and does not require any registration. And I left in my presentation the hyperlinks if someone wants to check. Of course, it's all in Romanian, but the access is there. Every year, our judicial system makes produces some sort of a 200,000 decisions, and 89 to 90% of it is published. What is not published is basically those decisions who are not on the merits of the case, and those who are taking in camera. So basically, if the criminal trial was held in under closed door, the decision also will not be public. I wrote here terms and conditions apply because there are certain exceptions to the publication, and we will explore them in a little bit there. And I mentioned that basically it is never published if the judgment does not refer to the merit of the case, but rather a procedural matter, like refusing to accept evidence or something. What is also not published, and this is a problem from our perspective, at least because orders of the investigative judges in Moldova, we have a special category of judges, perhaps like in other countries, who rule on arrest on remand, on special investigative measures, and these are referring to confidential materials, and they are not published, and they are not published even after 5 or 10 years, and this we believe is a problem because often the arrest on remand or searches or wiretap are automatically approved. And this poses a challenge to securing and ensuring human rights and fundamental guarantees. I will talk a bit later about the other side, the privacy and data protection. But basically in Moldova, there is an established precedent of the Supreme Court of Justice. And they mentioned that the publication of court decision derives from the principle of publicity. And this is enshrined in our Constitution and the European Court of Human Rights and Convention. And publication will always be conditioned on whether the court proceedings were held in camera or public hearing. And basically, this is the rules. If it's in camera, then the decision will not be public. If it's in open trial, then the decision must be public. However, the 3rd paragraph states that the publication of this decision can be in part restricted or even anonymized. There are 6 rules, and I will go very quickly through them. The first rule is that there is a prohibition, general prohibition to anonymize information concerning the court and the person who participate in their professional capacity. So the name of the judge, the name of the court clerk, the name of the lawyer, or the name of the prosecutor should always be public. Bailiffs, notaries, and all sorts. Second rule is that in criminal misdemeanors, civil or other trials, in order to protect the rights of the juvenile, the children basically, or the private life of the parties, the names and other information which could bring an interference in this protection rights will also be redacted or anonymized. The third rule concerns only the criminal cases, and basically it states that in criminal and misdemeanors, the names of the juveniles, the private parties, the perpetrators, instigators, authors of the crime will be never redacted, or meaning that if someone has, I don't know, killed a person, his name will never be redacted, even if he or she is a minor. And this could be a problem, but we'll talk about it later. Fourth rule, that some parts of the decision can be made confidential, meaning that, I don't know, if there is a state secret or there is a witness hearing in camera, and that part of the hearing minutes or information about this will be just blank, and this should be redacted after the judgment is final. There is also a rule. The fifth rule is that the name of the parties or person could be redacted if this protects a public interest. And last but not least, there is, if we had the first rule that the name of the professionals are never redacted, then we have a separate rule that states that the place of birth, the personal identification number, bank data, health information, car license number should always be hidden, no matter what is the procedure. So in short, these are the rules. And 2 years ago, we did a study on how this regulation, how these 6 rules are respected in practice. And what we have found, I'll talk in a bit about what are the statistics. Before that, let me just quickly tell you about granting anonymity. The rule is that you can ask for the court for your name to be redacted before a final judgment is issued. You can do so yourself, or the judge can decide ex officio if he believes that there's a matter of privacy or some other interest. He or she might decide in favor of the anonymity, like the European Court of Human Rights does. The publication of the court decision is in the responsibility of judges, but in fact, it all happens by the judicial assistant or judge clerks, and they are responsible before publishing the decision to retract all the information and basically respecting those 6 rules in every judgment. About access to case files, and I have looked into it, and it's more or less similar to what other speakers were talking. Case files are not publicly accessible, and there are, of course, exceptions. And in order to get access to a file, you need to go through a written request through the High Judicial Council, the Superior Council of Magistracy, which could decide in favor. For example, civil society organizations are doing research into domestic violence, and they want to get access to case files which were decided some years ago. They will file a request to this Superior Council of Magistracy, and taking into consideration privacy of data and public interest for the research purposes, this High Judicial Council will decide. It usually decides against granting access to files because of the sensitivity of information. In ongoing cases, you can get access to files only if you are a party to the proceedings, and even if you are parties to the proceedings, some access could be limited if the court decides that in the interest of the state or in the interest of a private individual, secrecy, administrative files must be not available to someone. The same goes in civil and criminal cases.
Sorry, time is 10 minutes past. So do you need
yes,
additional?
I will go quickly to the conclusion. So the problems with the current model, and we did the research that at least in 63%, this is not respected, that regulation with the 6 rules. And we have two scenarios. One, we have excessive anonymization, basically everything is redacted, or the other model where too much information is displayed. And this is an issue, we believe, of basically legal education and the fact that the judges and their assistants have a lot of workload, and this anonymization comes as an extra task. But there is a problem, at least in sensitive cases. We see that the higher the person it is, then the better his rights, his privacy rights are granted. So in practice, often this legislation on privacy and data protection, at least in our country, is used to protect public interest information. On the conclusion, I will say that in case of Moldova, in case of countries with transitional justice, access equals trust, at least for the time being. And we understand the importance to to respect privacy and interest of data protection. But we believe, as was mentioned before, that in the case of public officials or former public officials or big businesses, there is an there's a public interest to have all of this public. And this should be decided on case-by-case basis. I will end here, and thank you very much for your time. I will expect questions and comments if you have them now or later. Thank you.
Thank you, Ilya, for keeping up with time. So now we are behind schedule 20 minutes, caused mainly due to problems with technology. So we can open discussion and members can ask questions. But please name yourself, present yourself, and say to which presenter your question is going to. Can you? You can just show me hand, and I'll write down. So nobody has any questions?
Yes,
okay,
yes.
Ketevan Kukava. Hi, Jim. So second question from Jim. And
Georgi Davitorius.
Miss Best, Ellen Best, first question. I cannot see all on my screen. So Georgi Davituri. So, okay, let's start with Ketevan Kukava, Miss Kukava.
Hello, everyone. I am Ketevan Kukava, and I am representing Law and Public Policy Center. First of all, thank you all the speakers for presenting this useful information. I want just to express my opinion. I don't have a question. I want to focus on Georgia, and we need to take into account the current context in Georgia. Personal data protection should not be used as a pretext to prevent access to such public information towards which there is high public interest. And when it comes to the judgments, which are the end results of open justice, I think that transparency and openness should prevail, because otherwise the people will not be able to exercise efficient oversight over the judiciary. Although I am aware of the importance of personal data protection and I support harmonization with the EU standards, when it comes to the balance between these two rights, taking into account the Georgian context, I think access to public information should prevail. Even the GDPR, in particular the Articles 85 and 86, provides that the protection of personal data should be reconciled with the right to freedom of expression and information, as well as access to public documents. Therefore, there is a certain leeway for the states to regulate this issue, and we should focus on our local context and challenges. And even the Court of Justice of the European Union and the European Court of Human Rights published the judgments in full, and the personal data is covered only in exceptional circumstances. And we need such legislation that will ensure that access to judgments is not disproportionately restricted, and also unnecessary burdens should not be imposed on courts. And the best solution is a procedure when the individuals submit a substantiated motion to the court to redact their personal data only in such circumstances when the disclosure has a negative impact on their rights and interests, and that is when the disclosure might reveal very sensitive data. Therefore, there should be an exhaustive list of these exceptional circumstances when data protection prevails, and in all other circumstances, they should be made public in full. So this was just my opinion regarding the Georgian reality and how this problem should be solved, taking into account the challenges that we face. Thank you.
Thank you, Ms. Kukawa. So next in my list is, I also noted questions to have Lynn Hammergren, Ms. Hammergren, and also Ms. Leafley. Yeah. Okay. So Jim.
Yes, I don't want to give you the impression that all law professors in the United States have the first name Jim and a last name that's Italian. But I did want to make one comment and a question on Jim Moliterno's excellent presentation on the United States. And I learned a lot, Jim, things I should have known. But I didn't want everyone to be left with the notion that access to court records is absolute in the United States. There are times when the courts will allow records to be sealed. And I think, Jim, probably the most common of those is cases involving juveniles. So my question to you is, there are some exceptions, aren't there? And am I hitting on the right, in the right area here by mentioning juvenile cases, family cases?
Yes, you are, Jim. Thanks for the question, because I was hurrying to try to get through the demonstrations I was trying to do, and I didn't mention the exceptions that I should have mentioned. The exceptions in the US are less formalized than the ones that I've encountered in Europe, which are based on a statute, based on some code provision about data protection. In the US, it is more historically left to some discretion of the judge who has done the work. There are some kind of cross-cutting examples, just as Jim mentioned, with juvenile cases, protection of the privacy of minors, protection of adoptive parents, etc. So many of the exceptions do involve juvenile matters, as Jim just mentioned. It's also true, for example, that victims of violence, I should say sexual violence in particular, are often anonymized. Certainly not the perpetrators of sexual violence, but the victims. And the other place where we get a fair amount of sealed records is in the area of criminal investigation. So there are times when the documents that law enforcement has submitted to the court in order to get a search warrant or an arrest warrant of some kind. Sometimes if the judge makes a decision that revelation of this information would put the informant, the police informant, in physical danger, they will seal those kind of records. We just had this happen. It happens more than this, but just as a high profile example, in the search warrant for Donald Trump's compound in Florida, Mar-a-Lago, some of the documents were allowed to be open to the public interest, but there were others that were interviews by law enforcement with individuals that it was deemed by the judge that their lives would have been in danger from Trump supporters, quite frankly, had their identities been revealed and that they had spoken with police investigators, FBI investigators. So these are the main exceptions that I'm aware of. And thanks, Jim, for giving me the chance to go back and sort of amend my presentation with some things that are in my notes, but that I didn't get to speak fully.
Yeah, I see Jims are working in cahoots.
Yes, for sure.
Present the case. So, Mr. Davitori, you wanted to ask a question.
Hello, everyone. I'm Georgi Davitori from ID5. I have multiple questions. I'll start with the questions and then I will have small comments regarding the situation in Georgia. The first question addressed to the colleague from Germany. I have in her presentation, Ellen said that only when there is a final judgment rendered, if I understand it correctly, of course, only when there is a final judgment, and I guess you mean that when the last judgment is already in effect and there is no appeal time or anything, only then that the respective judicial acts are accessible to the public in depersonalized manner and there is no names and anything. So I have a question regarding what's the legitimate interest behind that. I understand personal data is not the legitimate interest there. What's the legitimate interest and why courts are not publishing or are not granting them as a FOIA request until the final judgment is rendered? Why is that? That's the first question. The next question is that you said that if there is a case of high public interest, the president of the court, not the judge itself who is considered the case, but the president of the court can say that, okay, now there is a brief of the judgment and make it accessible to the public, but no names again. So, but everybody knows who this case concerns, right? So we had the situation the same in Georgia, and I just want to draw the parallel why I'm asking the question. In Georgia, names of the defendants or the participants of the cases has never been public, technically. It was never granting of the FOIA request. What actually reduced and makes the huge problems in Georgia was that whenever we were asking a particular judgment to identify by names of the defendants or even by the dates of the judgment, the court said that I cannot give you the judgment because you can then identify the names by yourself because you know the date, for instance. So it's impossible to depersonalize the judgment. So that was the case why they did not give us, for instance, the judgment of Saakashvili or judgment of Merabishvili or anything. So, and of course, the depersonalization is a requirement of the GDPR. If, of course, we say that some cases of this part, Germany actually, I understand, they regard all of these cases should be depersonalized. I personally don't agree with that approach, but Germany actually does. So how do you solve this dilemma? This is the questions for Ellen, and there is also one question, I guess it's in particular towards Moldova, but it may address to all of the presentators as well. The question is when everybody, so in every court system, there are cases, and when there are some personal data or some state interest to protect and not to reveal the data, right? In USA, for instance, it's more or less, those reasons are extremely reduced. In Germany, for instance, it's extremely high. And whenever court decides that this case should not be public, for instance, there's a juvenile involved, and court said that the judgment should not be public. is there any means after the judgment is rendered, for instance, after 5 years, when there is no legitimate interest to cover this judgment anymore? Is there any mechanism to give some flexibility to the process, to review the, I don't know, the decision to depersonalize something or to give something or publish something or not later date if the circumstances will change? So is there any mechanism like that? And yeah, so that I also have another questions, but I won't ask them. I will also make some comments what's happening in Georgia. The Constitutional Court, the judgment of the Constitutional Court, I mentioned, there are also some important judgment right before 1 year before that particular judgment on the court cases. The Constitutional Court changed its own precedents that actually the previous precedent said that if the personal data includes right to freedom of information doesn't apply. So before 2019, there was a case against Green Alternative. The plaintiff was the Green Alternative, Georgia, and the Constitutional Court changed the precedent. That was followed after our ID5 case. And yeah, Kaka already described the decision. What's the problem currently, and the government was supposed to enforce this judgment in 2020. What's happening now is that I know ID5 personally had a lot of meetings. Previous year, we had a dedicated meeting. We met all of the Judicial Committee of the Parliament. We had the President of the Constitutional Court there and the head of the legal department there as well. And they actually, all of the questions were answered what the Parliament had, but they still elaborated legislation as we see now.
Georgi, sorry, we ran out of time. So maybe it's time to answer your questions from our presenters.
I will finalize in 30 seconds and I'll be done, I guarantee. And there's also another question. The main problem, the LELOS legislation is actually, they actually adopted and considered what ID5 have suggested. But there is also the one final question. According to the legislation of the draft law of the governing party, all of the burden, technical burden addressing regarding the considering which decision should be public and which is not, shall be decided by the judge considering the case. So in any of your legal systems, what's happening there? I understand judge has some role, for instance, to close the court hearing or not. But do judges actually decide in your country which case should be, which decision or court act should be public or not? That's my final question. Thank you.
Okay, lots of questions from Georgi. So first, I would ask to our dear Richterin Best, yes, to answer questions. Yeah, before you go directly to the answer question, I just want to say that in Germany, there's the 60, 70, even we Georgians maybe don't like this anonymization of court decisions. The 76% of population thinks that courts are independent.
Yes.
It is higher than England, where decisions are published and fully published, and there's a 71% this figure. It is still above the average in European Union, which is 56%. So it depends on the country. If country is fine with the, so yeah, sorry for stealing some time from you, but it's a problem because in Georgia we have, I'm sure in Ukraine, in Moldova, we still have problem with trust in judiciary and to get this court decision, to have access to all court decision. We see it's important to check if the justice is rendered in proper way. So that's how we see, because of our past and our context. So please.
Yes, but this is very right what you are saying. It's from your own history in each country completely different. And I want to say a few years ago, I had a meeting here with judges from China, and they were telling us that every hearing is streamed now. You can follow it in the internet, everything. I have my doubts that the trust in the Chinese judiciary is very high. So this is a different society, so to say. And in Germany, the protection of a normal person, like what we saw from Jim in the US, that you can see the criminal record of someone, this is unthinkable. We would not like it. We don't want it. Even if he's a perpetrator, a sexual harasser and whatever, we don't do it. To make it short, we have two rules. Of course, as I told you, from the Supreme Courts, the federal Supreme Courts, every judgment is published anonymized. Normally, it is normally everything is anonymized, and the high courts in the states also publish most or many of their judgments, which are from some interest, anonymized. These are the rules. And for the rest, you can do it. Sometimes you do it. If it's interesting, you publish it or not. Meanwhile, of course, some decisions are not anonymized as far. For example, we had a lot of claims against Volkswagen and against Mercedes-Benz. So of course, whom would you protect? It's a company worldwide known, and this is a strong plaintiff. So of course, you will not protect Volkswagen and you will not protect Mercedes-Benz. But for the normal person, of course, they feel protected. And this is one thing why people trust in judiciary. And this is one thing why people come as witnesses and so on. This is our history, and this is our system. And only in exceptions we go. Or I make an example. If you have a family case, for example, and the neighbor wants to know what is the outcome of it, and he would say, "I want to have inspection of the file," we would not give access, and we would not publish this decision. But if let's say a redactor of a law journal would say, your family court has, your judge has made a very interesting decision, we would like to publish this. It was not challenged, so this will not go up. Then we would think to anonymize it, and then it could be published in this law journal. So I hope it makes it clear. There are exceptions, but the first rule is always anonymized, and second, published is mostly by the high courts.
Thank you very much.
So, one question was, why is it like this? We are very careful because the court could be, there could be a complaint against the court saying, I want a compensation because you damaged my personal rights. You published my name or things like that. So we are careful with this because it's the right of someone, witnesses and whatever. So we are very careful with giving names.
Thank you, Ms. Best. There was another question. The next question was directed to all presenters. How judges, so it is again, if judges are allowed to decide which to depersonalize this information. So if I remember correctly.
The judge is deciding as long as the file is in the court, so to say, on his desk or in his, and then after the file has is finished for him, then it is up to the court president. If it's a civil case, if it's a penal case, it's a procuracy, so it's different different organized. But then it's not the judge who made the decision. It's only as long as he has not given his decision.
Jim or Mr. Kituaka, Ilya, do you want to answer this second question as well?
So just, I don't know if it's an answer to the second question or the fourth question, but there was a question about can it ever be changed in the future, a decision to seal some part of a record? And yes, it can be changed. There is no magic date or period of time. It's not after 3 years or 5 years or 7 years. Simply a request by one of the parties or by a media organization, perhaps, that goes to the judge who sealed the documents. If the circumstances have changed in terms of the need for protection of the individual's privacy, then the judge has the power to unseal, to open the materials. But there is no specific date. It simply is the change of circumstances that triggers the possibility.
Thank you, Jim. Ilya, do you want to add here?
Yeah, in our case, very quickly, there is no such rule that after time, the judgment which was taken in closed camera will be published. However, we advocate for that right now. Especially in cases which are on arrest on remand or use of special technique to surveillance for someone. We believe that after 5 or 10 years, disclosing this case will improve the judicial reasoning for future judges and lawyers, and it will at least be important from a scientific perspective. And as mentioned previously, the archive of the Supreme Court of Justice was digitized and it's publicly available. However, it is an advocacy effort so far, and not successful one, but we try.
Thank you. In my list, next is Ms. Lina Hammergren.
Yeah, thank you. And I will be very quick, although I'd like to say first, this has been really a refreshing discussion. You're getting to practical details. I have been talking about this topic with the two extremes, the judges who don't want anything published and the proponents of what Latin Americans and the Spanish call open justice, where not only is everything published, but everything is debatable by the public. So it's nice to be somewhere in between. I just have two questions. Well, I have lots of questions, but I'll just ask two. First, when these things began to be published, as judgments or opinions began to be published in Latin America, there was an issue of companies using bots to download them and make lists, particularly of workers who engaged in labor disputes so that they could be blacklisted. Is this still a problem, or has a way been found to avoid that? And the other, on the other extreme, I guess, is the French decision about anonymizing the names of the judges, because as one judge told me, if my name is there, they will come after me. Is that having any effect on this discussion, or is that just left to Western Europe or countries that already more or less agree with that? And that's it.
Thank you very much. So who wants to answer a question about bots and the French decision about anonymization of judges? Jim, have you heard about
no, actually, I had not heard about that decision in France. It's very interesting to me. I'm not aware, at least, of any case. There may be one, but I'm not aware of any case in the U.S. of judges' names being anonymized or taken out of the documents. So, as far as I know, that hasn't been done in the U.S.
Was there any case of misuse of public information contained in the court files or this court database?
Yeah, historically, there have been such instances. For example, in the 1960s and 70s, there were quite evil organizations in the US South that managed through litigation to get membership lists, for example, from the NAACP, civil rights organizations. They managed to get that into a court file by kind of manipulating a court case that they brought. And because it was open to anyone to have access to it, these organizations then went about a process of very discriminatory activity against all the members of a local civil rights organization. So yes, it can happen. And I would expect today that a judge who essentially saw that happening would use the opportunity to seal that kind of information because of the abuse that was made of it in the past.
I see. Thank you.
Talking about the abuse, Irakli, maybe...
we are not finished with the questions. Maybe other presenters are, and we have this list of who wants to ask questions.
Yeah, okay, I will talk later.
Miss Best, can you comment about anonymization of the judge's name? Because there was some discussion in Georgia, I remember, about that.
If you go to the website of our Supreme Court, you will find the names of the judges who decided. And if you go to Law Journal, there are no names of judges because it's only about the case. And when I published I didn't. I don't know. It was with my name. Yes. Then it's up to the judge how he likes to feel good. Yeah.
Okay. Thank you. And I have Miss Ellen Lefley. I'm correct. I'm pronouncing your name correctly.
Yeah, that's perfect. Yeah. Thank you so much. I'm joining you from the UK, and I work for Justice, which is a human rights and law reform charity. We're scoping for a new project on transparency and open justice, and I'm really interested in people's thoughts around technology and the opportunities and also the obstacles that it poses to open justice. I think maybe my question might be best starting off with Jim, because of course you shared with us a key tool through which justice has been democratized to the masses, and I was able to go on Pacer and sign up during this conversation. But I also used to be a family law barrister, and I'm aware of cases, and also COVID is an extra variable in all of this, right? And all of the online justice and proceedings that have happened, this brave new world that we're trying to navigate. I'm aware of private proceedings and children proceedings are presumed private in the UK, as I know there are many places where there have been videos taken of proceedings and private information of court proceedings shared during the coronavirus pandemic. I'm also really interested in law tech and the challenges that proposes. I'm really interested in Lynn, you mentioned bots, and there have been some who are concerned about creating databases of decisions, meaning that judicial decision making can go through an algorithm and people can game the system and try and get before one judge and not another, because the analysis of their thousands of decisions means that they might be a more sympathetic tribunal, things like that. I don't think that that's necessarily a reason not to do it, but I'm interested in people's thoughts around obstacles that technology might pose to the transparency project and the way forward.
So I don't have a great answer. That's a really wonderful and very important question. I am somebody who regards himself as tech competent, not tech savvy. So there are different layers, right, of people in their relationship with technology. I have heard also of instances like you describe during COVID, in which there were basically people gained access to Zoom recordings and so forth, and courts were conducting hearings on Zoom. The only thing I would say is that, it doesn't matter. After COVID, this is not going to go away entirely any more than COVID will go away 100%. Courts have realized, and parties to litigation have realized, that they like doing certain activities, even court activities, remotely because of the expenses that are saved of travel, having to live in the city where the proceedings are taking place for extended periods of time. And so we shouldn't think that remote court activities will suddenly end on some day in the future when someone says COVID is over. It won't end. So the concerns that you express, we have to, I think, continue to guard against, because they do continue to pose risks, especially in cases such as you mentioned, that we would expect to be sealed, to be private. So I don't have a great answer other than, yes, you're right. We have to be careful about this going forward.
Thank you. I don't know if any of the other speakers wanted to have any thoughts.
Yes.
I have a very quick comment. We as well had this discussions like how technology is evolving and how basically downloading every decision on a particular judge can make a sort of a model on how this judge is, what kind of argument he likes, or when is the time to better pursue with an application. These are definitely very, very interesting questions on how artificial intelligence will change and how algorithms which we will feed will give us information that even that judge is not aware of. But I must say that in the case of Moldova, at least, when the trust in the judiciary is so low, these arguments are somewhere in the future, mostly because a lot of us, and us included, don't actually understand or haven't seen a model which already works and can provide such information. But this is definitely a concern that we must look into.
Thank you. Kaha, you had a comment or question?
Yeah, thank you. First of all, I have a question to Jim, because United States looks like a classic model, classic open system. In the three models that I presented, I think the United States is on the top of being classical on the side of openness of public information. So my question is about some personal data that may be abused. For example, the bank accounts, the ID, insurance, security numbers. Those, how do you handle those information in the case files?
Yeah, those things are anonymized. Those things are deleted. So very personal information about banks, about social security numbers, government identification number, those kind of things are redacted and are put into simple kind of code that doesn't reveal it. So yeah, the US, I think, is very, very open. It is on the open end of the spectrum in terms of access to court documents and so forth, but it is not, as I think Jim Alfini mentioned and made clear, it's not 100% open. It's not as if every single private detail about every person who's ever been in a courtroom is freely accessible to anyone else who cares who cares to look at it. So I want to be clear about that. There are a lot of things that are super personal that are anonymized.
Okay, two more questions, very simple, very, very smart, very quick questions. Let's suppose I'm a law professor and I have been arrested by the police for drunk driving. And I don't want my record to be publicly available for everyone, especially for my students. So can I go to the court and say, excuse me, can you actually close that information because it's private? This is
well, you can ask anything you want, but that request will be denied with some laughter.
Okay. Okay.
So it's a hard life. If you get arrested for drunk driving, people will be able to see it. It's not something we get to keep secret.
Excellent. So, and my third question would be, probably I know the answer, but just to clarify, let's say I want to see who is living in my neighborhood. So I have 10 people living in my neighborhood, and I want to know who are they, if they had any kind of civil dispute, any kind of trouble with the police, any kind of tax evasion or something. So I go to the search, to the pacer, and I type the name of my neighbors so I can find out their family, their divorce cases, their criminal history, their administrative fines, tax evasion. So is that what can I do about my neighborhood in the US?
Well, if they have those activities have resulted in criminal charges, yes. If they are evading taxes very successfully and have not been caught, no, right? I mean, you can't find out everything about everybody's activity. The same way with, you said, divorces. Yes, in fact, in that search engine that I showed you for the state of Virginia, you could find whether someone has been a party, one side or the other, of a divorce action. Some of the information inside it will be sealed, right? You're not going to find every detail about the allegations that were made back and forth between family members and so forth. But the existence of a file would be accessible. So I think you wouldn't be as successful as you sound like you would like to be, Kaka, in finding everything about everybody in your neighborhood. But you will find some things, and it will be publicly available, some things.
Okay,
thank you for your questions. We are running out of time, I guess, but we can still get one or two quick questions if still other members. So I know you have maybe 10 questions, but I'm asking some other members if they have any questions. If they do not, then go ahead. One moment.
Just so technical comment, yes.
Okay, please go ahead.
Just a technical comment. We have here in our Zoom community, Matthias Dvorak. He's a law student from Czech Republic, and he's specifically studied this question of public access to the court documents in Czechia. So probably he will also tell us just a few words about what is different. What is different in Czechia?
Yeah. I'm sorry, but we are running. We are 15 minutes behind schedule. We can give just 1 minute if you have very useful. It's your experience, of course. It's very useful, but it's just very short comment, please.
Okay, thank you so much. Do you hear me?
Yes.
Okay. Thank you, Mr. Kacha, for your invitation and for my introduction. And very briefly, how is the situation in the Czech Republic? The three, Supreme Courts of the Czech Republic, Czech Constitutional Court, Czech Supreme Court, and Czech Supreme Administrative Court, publish their decisions, all of their decisions on their websites. And the most important decisions are publishing in the collection of the decision of these courts, which is publishing by the state and also in their websites. And this type of the most important cases is something like a precedent for other Czech courts but it isn't precedent because Czech law system doesn't know the precedents as is it in the United States, because we have the civil law system. And the second thing, which is interesting, there is a new statute about the publishing of the law of the court decisions of other courts, as high courts, regional courts, and district courts. And all of these courts are obliged to publish their judgments, just judgments, no resolutions, just judgments, since this July. Since July 2022, is mandatory for all of these courts publish their judgments. But the other conditions about this obligation will be provided by the decree of Minister of Justice of Czech Republic, and this decree still has not approved. So this is very briefly about the Czech Republic. Thank you.
Are they anonymous, Matthias? Sorry, are they anonymous?
Some of them are anonymous, and others are pseudonymous. So there are just the first letter of the name and first letter of the surname of this person.
Okay.
But there isn't the unified practice still, because we are waiting for the decree of the Minister of Justice.
Okay, thank you.
So, if there are no any further questions, we can summarize our discussion. I want to thank our presenters. It was really fascinating to hear the experience and different experience in different countries. We saw division between court discretion, judge discretion to seal up court files, or the legal normative approach to provide anonymization exceptions from publicity. We saw also rule in Germany. There's a rule to depersonalize everything, anonymize everything, in comparison with the United States, where there's the rule of to publish everything. So it's depends on the context, on tradition, on country, and on society. What society is looking waiting from judiciary. So we also still see trends in this part of the world, especially I'm talking for Georgia, that we are striving for more publicity, but also in the same time we have to find some golden middle, not to harm personal data protection. So not to go to extreme from either side. So I want to thank our participants, presenters, and we are going, I hope we'll have some other topics within the International Network of Judicial Reformers to discuss, and looking forward for your participation. Thank you very much. Keta, do you want to add anything?
I want to thank everyone for this very fruitful discussion. I welcome our new members of the International Network of Judicial Reformers who are attending now our discussion. And thank you for this for our excellent presenters, for this very useful information about public access of court decisions. And I hope to see you, everyone, on our next discussion. Thank you very much.